Thank you very much, Mr. President. And thank you to my colleagues who have contributed to this debate today. I would first wish to express my appreciation, as I seem to be getting into the habit of doing, to my colleagues on the independent bench for the thoughtful, careful, studied commitment to nation contributions. And so I would like first of all to address some of the remarks that have been made today by my independent colleagues, to reassure them that some of the concerns which have been addressed are already taken care of in the bill which the government wishes this House to pass, and to reassure them further that in one particular instance, which I will come to, I have listened carefully to the comments and I will make a further contribution. First of all, if I may, Mr. President, address, beg your pardon, some of the comments of learned Senator Sipasad, who went into some detail on some of her concerns, which I think happily I am able to address by a careful review of sections of the bill which is before us today. She listed, as I took note, 7 or 8 concerns, some of which were subdivided. And I will attempt to deal with concerns 2 to 7 first. I will deal with concern number 1 last, because when I come to deal with concern number 1, I will want to address one of the concerns that has also been addressed by her independent colleague and Senator T.A. So turning first to the concern raised with respect to lack of formal discovery provided for in the bill, which was the second of the concerns addressed by Senator T.A. I think those concerns, if I may say through you, Mr. President, can be addressed when we read sections 44, 45, and 28 of the bill together. Because if what we are concerned with is a lack of process for formal discovery in the arbitration procedure, when we look at section 44 and 45, first of all, it's very interesting that the draftspersons, UNCITRAL, who at the end of the day are the principal draftspersons, it's very interesting what is said in the bill. So clause 44 tells us an arbitral tribunal, or importantly, a party, remembering always that we are concerned here with giving effect to the contractual intention of the parties to the agreement. An arbitral tribunal or a party, with the approval of the arbitral tribunal, may request from the court assistance in taking evidence, and the court may execute the request within its competence and according to its rules, that is to say, the court's rules on taking evidence. 45(1). A party to arbitral proceedings may use the same court procedures as are available in relation to legal proceedings to secure the attendance before the tribunal of a witness in order to give oral testimony or to produce documents or other material evidence. Subsection 2, the court procedures under subsection 1 may only be done with the permission of the tribunal or the agreement of the other parties. And the court proceedings, subsection 3, may only be used if A, the witness is in Trinidad and Tobago, and B, the arbitral proceedings are being conducted in Trinidad and Tobago. Subsection 4, a person shall not be compelled by virtue of this section to produce any document or other material evidence which he could not be compelled to produce in legal proceedings. We remind ourselves, Mr. President, that court, used as that word only, court, because there are other passages that refer to state court or competent court. We'll come to that. But we remind ourselves from the definition section of the bill that court is defined to mean the Supreme Court of Judicature. So when we read sections 44 and 45, we are reassured for purposes of formal disclosure and formal discovery purposes that either at the instance of the arbitral tribunal or at the request of one or other of the parties to the arbitration can ask the court, the Supreme Court of Trinidad and Tobago, to invoke all of its procedural force to ensure relevantly within the context of the dispute that is taking place that there is formal discovery of process in the course of the arbitration. And there is also section 28 of this bill which deals with disclosure. 28 reads, subsection 1, an arbitral tribunal may require any party to promptly disclose any material change in the circumstances on the basis of which an interim measure was requested or granted. And it continues at subsection 2. That deals with the interim measures and the preliminary orders. But the point there, without belaboring it unduly, is that both the tribunal and the court, at the request of a party, are able to invoke disclosure procedures, full and ample formal discovery within the rules of the court's evidentiary proceedings. So that, I hope, addresses the first concern, number 2, of Senator C. Prasad. Her second concern was that it will not always be cost-effective for parties to agreements to be able to undertake the cost of arbitral proceedings. Well, that is a truism, that is a reality. It is often not the case that parties can earn enough money to afford expensive lawyers to go to court. We will have to deal with that as best as we can, but ultimately, at the end of the day, the legislation that we are asking this Senate to pass is not to exclude access to justice, but to improve access to justice. And we will have to deal with the availability of parties to be able to afford to access the arbitral proceedings within the framework of the agreements which they have signed. One would assume when they enter into the agreements, they have some means by which they would expect to be able to enforce the agreements which they have voluntarily and consensually entered into. Senator Timal made the point as well, point number 4, that there is limited precedent value in arbitral proceedings because the awards of the arbitrators, unlike a court decision, isn't a precedent which can be relied on. And that is correct. But there are two sides to every coin. And the flip side to the coin of the absence of precedent is the encouragement of the arbitral process to allow for flexibility from case to case on every occasion that parties to an agreement invoke the arbitration clause in their agreement and seek to appoint arbitrators who will be regulated by the provisions of this legislation when we pass it into law. And of course, respecting the fact that the precedent value of an award of an arbitrator in principle is limited by the fact that the parties to the agreement also ex necessity, have agreed that the proceedings of the arbitral tribunal will be confidential. So it's both sides of the coin, and we accept that the awards of the arbitrator will not be published so as to be precedent, but we have every confidence that given the fact that the parties to the contract have agreed to this process, given the fact that they have the flexibility outside of the norm which is available in a court of judicature to select arbitrators with reference to their specialized expertise, that we can expect in the norm, there will always be exceptions to the norm, we can expect in the norm that the parties to the arbitration agreements who have invoked the arbitral procedures will result in getting what they consider to have been justice done to them. The lack of the fifth point that was raised by Senator C. Prasad was the lack of public scrutiny and transparency. And I would suggest that the very sections that I have referred to in the context of confidentiality, because the process will remain ultimately confidential, but in the course of the process, while the parties are engaged in the jurisdiction of the arbitrator and engaging the procedures to allow them access to justice, I would confidently expect that the sections that I just spent some time on in respect of formal discovery, sections 28, 44, and 45, will conduce to a degree of public scrutiny and transparency inter partes, those parties who are before the arbitration tribunal in order to get justice. And of course, we'll have to rely on, which is a point that I will come to when I address one of the points raised by Senators Dayal Singh and Richards, we will have to rely on the integrity of the arbitrators who are chosen by the parties, and therefore, in consequence, the integrity of the process. We live in, regrettably, an age where mistrust has almost become a norm of our existence, but I'm not one of those who sees doom at the end of the corridor, and I think that we have to continue to work towards improving our conditions and therefore enabling this legislation, which will be passed into law, to allow for greater access to justice. In spite of our imperfections, we are improving the whole lot. And one of the other points that was made by Senator C. Prasad had to do with the concern that she raised about the confidentiality of the process. And that is a flagpost of the process, so that I can understand the concern that emanates from the confidentiality provision, because in our society it could be used as a synonym for secrecy and all that is ill with secrecy. But ultimately, at the end of the day, on the basis that I have just articulated, I think that it conduces to a process that will allow an honest exchange of positions with a commitment to moving forward. And that takes me directly to a point which was made by my colleague, the Minister of Trade and Industry, which I applaud. And it is the simple point that she made when she was making, my colleague Senator Gopi Schoon, when she was making her contribution, that the parties will engage in the arbitral process while preserving their relationship. And that is one of the unique features of the alternative dispute resolution process, because in an alternative dispute resolution process, what we seek to discourage is gloves off, fight at all costs, and walk away the victor and leave the vanquished sprawled on the floor with not a breath of life left in her or his body. That is not the process of alternative dispute resolution. The process of alternative dispute resolution is to recognize and respect the fact that people will have differences, but their differences need not destroy them, nor be used as tools to destroy each other. You can engage your differences, resolve them, and in the commercial business environment, you can continue to do business with each other. So I applaud Senator Gopi Skoon, my colleague, Minister of Trade and Industry, for reminding us of that parties will engage in the arbitral process while preserving their relationship. And that speaks to the essential need for the process to be preserved in a condition of confidentiality, so that howsoever the dispute is resolved, at the end of the process, the parties can shake hands and hopefully can continue to engage with each other in their commercial relations for the betterment of their individual enterprise and for the national societal betterment. Senator C. Prasad spoke to a couple other things that I will just wish to address briefly. The potential disadvantages, the limited appeal was one of the concerns that she raised. And that raises an important point in the frame and the ethos of this legislation, because we recognize that in this legislation, when we pass it, as I hope we will, the court is given a limited role by way of appeals. And that is deliberate, and that is the choice of the parties who ultimately have chosen an alternative option of the arbitral process. Because what we recognize is that the court process can be time-consuming, and it can give an unfair advantage to parties who are engaged in the litigation process. I have been an advocate for 40 years. You can get quite involved in the dispute without the resolution in sight and yet walk away the victor, because ultimately the adversarial process does not necessarily reward truth. It rewards strategic and skillful maneuvering. And that is what we are seeking to avoid by encouraging frank and candid exchanges in the interest of persons continuing to do business. And that is why the appeals are limited. But it does not mean that you do not have access to court. Throughout this bill, and I dealt with it in my opening, there are any number of instances in which the bill makes explicit provision for the parties to have access to the supervisory jurisdiction of the court, but limiting it to the first instance level of the High Court and not taking it to the level of the Court of Appeal. So that is the limitation, but it is not that the discretion and the jurisdiction of the High Court to correct patent errors is being excluded. And therefore, when we talk about limited appeal, we have to accept that the courts can be availed, but not to the extent of appeals all the way to the Court of Appeal and the Privy Council or the Caribbean Court of Justice, depending on which jurisdiction we come from within CARICOM, because ultimately we want an early resolution of the dispute so that parties can continue to do business. It is, for instance, significant that in the encouragement that is given, and I've dealt with it already, I won't repeat myself, in the encouragement that is given for arbitrators and foreign representatives to come into Trinidad, the seat of the arbitration under this bill, you are allowed to get the result in within 30 days. And if you get the result in on a fair process within 30 days, you get tax exemptions for getting the work done briskly. Because ultimately, what we want is for people to continue to do business with each other. There were other very telling contributions from some of my other colleagues on the bench, and I will turn to those now with the limited time that I have left. Senator Paul Richards made, as is a habit of his that I look forward to being privy to, telling contributions. So that he made a point that is of interest when he spoke to the fact that he hoped that the advancement that we will be making in Trinidad and Tobago by adopting the alternative dispute resolution route will trickle down and will persuade others in our society to recognize that progress is going to be made by those of us who are able to resolve our differences with amicable embrace as opposed to adversarial disgrace. And it reminded me to remind this House, Senator Richards's contribution on the advantage of alternative dispute resolution. That there is a pedigree that this society can be proud of in terms of alternative dispute resolution. And that pedigree, Mr. President, is taken from as far back as 1966, the Industrial Relations Act of Trinidad and Tobago. That was Trinidad and Tobago's early embrace of alternative dispute resolution, because you will see in Section 12 of the Industrial Relations Act that parties are encouraged, even in the face of acrid disputes between employers and trade unions, to seek conciliation before the Industrial Court of Trinidad and Tobago. And that is legislation that has been on our law book since 1965. And there is actually a division in the Ministry of Labor, the Conciliation, Advisory and Advocacy Division, that is responsible for managing the resolution of labor conflict in the society, including the private sector, state enterprises sector, and specific public sector entities. And one of the services offered by that division is dispute resolution, where conciliation proceedings are conducted between employers and unions in rights disputes, examples, dismissals, suspensions, warning letters, etc., and interest disputes. So our resort to alternative dispute resolution in this country has been trickling up since 1965, and what we are doing today with the passage of this bill into law will be to give flower and blossom to an early desire of this society to be better able to resolve its disputes without unnecessary conflict. Senator Richards also spoke to Section 60 of the bill, and I was pleased to hear him, as he did, interpret the section in the way that he did. And it is very interesting because the disclosure that is spoken to in Section 62, when it is read carefully, 60 subsection 2 that is, when it is read carefully, is not a prohibition against disclosure, because subsection 2 ends or begins unless a disclosure, and then certain things are authorized. So one could almost read it in the converse to mean notwithstanding subsection 1, that is to say, arbitral proceedings shall be private and confidential. Notwithstanding that, disclosure may be permitted in the circumstances outlined at sub A through to sub G of subsection 2 in the discretion of the arbitral party or a party to the dispute. So again, that is significant, and I was heartened to hear Senator Richards speak to his interpretation of Section 62 correctly as he did. And that brings me to one of the points that was made by Senator Dialsingh, because he, with justification, raised the concern about corruption. And I want to reassure Senator Dialsingh, as I reassure Senator Richards and all of the senators who have the true interests of this country at heart and are interested in legislation that will promote the national interest, that even in the evolving reality of the arbitral tribunal, there is the recognition that the all-pervasive corruption about which we are all concerned cannot be taken for granted nor ignored by a fair justice system of which the arbitral proceedings will be part. And with your leave, Mr. President, I would refer this House to an article out of the International Bar Association. That article is headed, if I may, it is headed Addressing Corruption Allegations in International Commercial Arbitration and Investment Arbitration, dated February 21st, October 2022, by Stéphane de Nafacel of Nafacel, Paris, Salom Garnier of Paris, and David Duran Hernandez of Paris. Paragraph 1, with your leave, states, corruption is as disapproved as it is widespread, both in the public and private sectors. It's a long article, and there are two other articles. I commend it in its entirety to my colleagues. There are two other articles that are of interest by way of reassurance to the senators who are concerned to ensure that the confidentiality of the arbitration process shall not derail the transparency and accountability which all persons concerned to expose corruption must remain focused on. Paragraph 15. Another possibility for arbitral tribunals to bar investors' claims has been to apply the clean hands doctrine, which requires that the claimant should have a proper conduct. Indeed, if some form of illegal or improper conduct is found on the part of the investor, his or her hands will be unclean. His claims will be barred, and any loss suffered will lie where it falls. This doctrine has been used by arbitrators to avoid granting access to international arbitration to resolve disputes because it is evident that its act had a fraudulent origin, and as provided by the legal maxim, nobody can benefit from his own fraud to absence of fraud in his conduct at the time of formulating his claims. And paragraph 28, effectively, as arbitrators have become increasingly active in the fight against corruption, I repeat that, effectively, as arbitrators have become increasingly active in the fight against corruption, they need to be careful in rendering enforceable awards that do not violate international public policy. Therefore, an award in which allegations of corruption are ignored or in which an unlawful act is legitimized in contravention of these principles run the risk of being overturned. So we have an international consciousness in the learning that is being applied to judge, assure, and interrogate the conduct of arbitrators, that they are on notice not to permit corruption to derail the process which they are engaged in. I dare say that as we pass this legislation into law, we will, as I have already committed, keep it under review. And if there are further amendments that need to be brought to the table, we will be returning to the Parliament. We will keep it under review. But for the time being, I would urge the members of the Senate to support the government's efforts to pass this legislation into law. With respect to Senator T.A, how much more time do I have, Mr. President, if I may ask?
5:38.
Thank you very much. With respect to Senator T.A, I want to spend a little time reassuring Senator T.A with respect to the concerns that he addressed, all legitimate concerns, starting with Section 4, which he was concerned about, 4.2 in particular. I would recommend that we read Section 4 in its entirety, because I understood Senator T.A.'s concern to be that Section 4.2 was placing domestic arbitration at something of a disadvantage in terms of the unenforceability of the Act in relation to domestic arbitration. I hope that I did not misunderstand the learned senator, and if I did, I will give way to be clarified. Section 4 reads in its entirety, 4.1, this Act applies to domestic arbitration and international arbitration subject to any agreement in force between Trinidad and Tobago and any other state or states. So we begin with the clear, articulate, express provision that says this Act applies to domestic arbitration and international arbitration. We remind ourselves that the immediate preceding section, Section 3, tells us this Act binds the state. So the Act is all-encompassing. It does not seek to apply to any particular class or body of persons to the exclusion of others, except where it makes particular exception. And that is where subsection 2 then takes us, the subsection which caused Senator T.A. some concern. It reads, the provisions of this Act, except sections 11, 12, 30, 31, 32, 56, and 57, apply only if the place of arbitration is in Trinidad and Tobago. And subsection 3 goes on to say this Act shall not affect any other written law of Trinidad and Tobago by virtue of which certain disputes may not be submitted to arbitration or may be submitted to arbitration only in accordance with provisions other than those of this Act. Read in its entirety, we begin with the understanding that the court to which we are going to turn when we look at sections 11 through to those sections which are accepted is not the Supreme Court of Judicature, which is defined as the court in the definition section of the legislation. So what subsection 2 is saying is, bearing in mind that this is a piece of legislation that is going to apply in Trinidad and Tobago, where Trinidad and Tobago is the seat of the arbitration, in limited circumstances where it will be called on for application to circumstances arising out of Trinidad and Tobago, the Act may not apply because the national law of the countries outside of Trinidad and Tobago will have to be allowed to apply according to those national laws. So if we go immediately to section 11, we see that section 11, one of the accepted sections, says, a court before which an action is brought in a matter which is the subject of arbitration agreement shall, if a party so requests, etc. And we see that that section, read in its entirety, refers in the first instance to a court in which an action is brought on an agreement. The agreement could be an agreement struck anywhere. It could be an agreement struck in Paris, which is subject to the national laws of Paris, or it could be an agreement struck in Venezuela, according to the laws of Venezuela, wherever. It begins, a court before which an action is brought in which in a matter which is the subject of an arbitration shall, if a party so requests, refer the dispute to arbitration. So what happens is that if it applies in Trinidad, this Act will apply to regulate the dispute according to the court's jurisdiction, the Supreme Court of Judicature. But if it is in a court outside of Trinidad, well, then the court outside of Trinidad will have the appropriate jurisdiction. When we turn to the other subsections, section 12 It is not incompatible with an arbitration agreement for a party to request before or during arbitral proceedings from a court on an interim measure of protection and for a court to grant such measure. And that is again consistent with the fact that you are dealing there generally with an arbitration agreement, which could be an arbitration agreement subject to the national laws of Trinidad and Tobago, enforceable in Trinidad by our courts or in a country other than Trinidad and Tobago. That point is made even clearer when we go to section 30, the section next accepted by the section 4 subsection 2. It says, beg your pardon, Mr. President, recognition and enforcement. Subject to section 31, an interim measure, etc., issued by an arbitral tribunal shall, irrespective of the country in which it was issued, be recognized as binding and, unless otherwise provided by the arbitral tribunal, upon application to the competent court. So the draftsman here is using a turn of phrase to delineate and underscore the fact that he is not referring to court in the normal course as defined in the Supreme Court of Judicature definition section of this legislation, but to the competent court. That is to say, the competent court of the state in which the arbitration agreement is going to be capable of enforcement. And that is why those sections are accepted by section 4.2. If we were to look at section 30, subsection 3, the court of the state where recognition or enforcement is sought may, if it considers it proper, order the requesting party to provide appropriate security. So there is a distinction made between the Supreme Court of Judicature enforcing its jurisdiction in the jurisdiction of Trinidad and Tobago, that's the general application of section 4 subsection 2, except when applicability of court's jurisdiction arises in other national laws to be enforced by those other national courts. So I hope I have addressed in some small measure the concern which Senator T.A had on section 4.2. It can't be read on its own, it must be read in its entirety, not only in relation to this section in its entirety, but on the canons of construction. It must be read within the framework of the Act as a whole. Senator T.A also had a concern about section 5E, the objects clause, which says it incorporates the UNCITRAL law, and he was expressing the concern that perhaps it should go on to say, subject to the provisions of this act. Well, I can understand the concern, and it is a legitimate concern, because you can't have a national law that incorporates a model law outside of the country and make the national law subject to the changes and the exigencies of that international law. But that is not what is happening here, because at the date at which we pass this bill, and it becomes the law of the state of Trinidad and Tobago, so much of the UNCITRAL model as we adopted is what becomes the law of this state. And always, going into the future, the law will be always speaking to continue to apply for purposes of enforcement in Trinidad and Tobago according to that law. If UNCITRAL were to change their model in 2025, we would have to come back to this Parliament to ask the Parliament to allow us to amend our national law, the Arbitration Bill 2023, to keep pace with the amendments that UNCITRAL may be promoting in the future. So we start with the fact that this is the law, it binds the state, it applies to all domestic and international arbitration within Trinidad and Tobago and without, and it is to be applied at the date of its passage, going into the future, to apply that which we inherited from UNCITRAL at the date of its passage. And the sections that Senator T.A expressed concerns about are also addressed, sections 8 and 9, by understanding that the Supreme Court of Judicature of Trinidad and Tobago is the court that will continue to have the limited jurisdiction in its supervisory jurisdiction to compel adherence to the laws of Trinidad and Tobago. And there's an interesting judgment, with your leave, Mr. President, which has emerged out of this jurisdiction dated the 14th of December, 2022, on the existing Act, Arbitration Act, Chapter 5, Number 2, which we will expect when we pass this bill into law will be repealed. And it is the decision, the OAS decision, Civil Action 2022, number 01832, a judgment of Mr. Justice Frank C. Prasad, dated the 14th of December 2022. And he was called on to apply Section 19. Senator Lakshmidial spoke to Section 19 of the Arbitration Act. Even in the very limited circumstances of Section 19 of the Arbitration Act as it presently obtains, this is what the judge, Mr. Justice Frank C. Prasad, had to say as a matter of proper statutory construction, to paragraph 24, in construing the provisions of the arbitration agreement regulated by that law. The court also has an inherent jurisdiction to set aside an award when the following factors apply, namely if it is A, subject to an error on the face of the award, B, wholly or in part in excess of jurisdiction, C, subject to a patent substantive defect, or D, subject to an admitted mistake. 2 points emerge from that dictum in the judgment of Justice C. Prasad. A Supreme Court has and is endowed with the amplitude of what is known as the powers inherent in a Supreme Court, and will always have the jurisdiction to apply the law as it stands, either at common law or statute.
AG, you have 3 more minutes.
Thank you, Mr. President. The significance of that is that in the absence of a complete ouster clause, and sections 8 and 9 of this bill are not complete ouster clauses, they expressly speak to and continue to apply the jurisdiction of the Supreme Court of Judicature, the jurisdiction as an inherent court of jurisdiction will continue to apply. So that in answer to Senator Timal's concerns about sections 8 and 9, I affirm the fact that our court will continue to be able to exercise the amplitude of its jurisdiction. Mr. President, I am an optimistic, positively minded person, and I am loath ever to rise unless I am given good cause to rise, to take objection to anything that is available to be said by any of our citizenry in the freedom of speech which we are blessed to express in this country, and particularly protected in this hallowed hall in exercising. But as I end and I ask this House to embrace the bill that is before it, the Arbitration Bill 2023, on Standing Order 46-8, in which judges of the Supreme Court or other persons performing judicial functions shall not be raised except upon a substantive motion moved for the purpose. I want to go on record to say I abhor the irresponsible and dangerous comments of Senator Mark today. Leave my wife out of it. Do not call my wife's name as a judge of the Industrial Court of Trinidad and Tobago in this chamber in your political guile. Mr. President, I beg to move. Thank you very much.